All right, good evening, ladies and gentlemen. We're going to go ahead and start this regular scheduled meeting of the City Council for January 11th, 2022. We're going to start with Pastor Trahan from Bible Baptist Church. He's going to lead us in a prayer, and then we're going to have the Pledge of Allegiance led by Councilmember McPartland. Mr. Trahan, would you like for us to rise or remain seated? We'll rise.
Thank you all. I want to read a verse of scripture before we get started here. In 1 Kings chapter 3, Solomon says that he has been chosen to lead his people after his father David. And he says, "But I am but a little child, and I know not how to go in or come out." And he goes on to say, there's such a great people here, and he doesn't understand the things to do. So he asks in verse 9, "Give therefore thy servant an understanding heart to judge thy people, that I may discern between good and bad, for who is able to judge this thy so great a people?" And God said unto him, "Because thou hast asked this thing, and hast asked not for thyself long life, neither hast asked for riches nor thyself, nor have asked for the life of thine enemies, but hast asked for thyself understanding to discern judgment, behold, now I have done according to thy words. I have given thee wise and understanding heart, so that there is none like thee." Mr. Dodd, Mr. Nunn, Mr. Jones, Miss Dixon, Mr. McPartland, it is my solemn plea and my solemn prayer that you guys do as Solomon did here. Ask for a wise and understanding heart to lead a great people. Now, Sebastian is not the nation of Israel. I understand that. But there is a great people here. And I ask that you lead these people as Solomon led the children of Israel. So with that, let's pray. Dear Lord, thank you so much for this blessed day. Thank you so much for the blessings you've bestowed upon each and every one of us. Thank you for the ability to even be here today. It is a gift of God to do such things. I ask that you bless these chambers, and I ask that you bless not only the city council members, but everyone involved in making this city run, because it is a great people that we're praying for here. I'm a transplant here from only 4 years ago, and there is something special about this town, Lord. And I pray that you help to lead it in a way that honors and glorifies you in everything that we do. And I pray that these city council members set aside agendas, preconceived ideas, and work together to do that which, exactly what the Bible says, that which was good. And to know the difference between that is good and what is bad. And to help them to have a heart to serve the people as Solomon had a heart to serve and judge his people. I thank you for everything you've done for us, Lord. I pray that you put a hedge of protection around these city walls and get rid of any of the negative or attitudes that have been in here in the past, and help to move forward from things that has caused strife and hardship in this city. I pray that they do this with a humble and obedient heart and a humble and obedient spirit. In Jesus' name we pray. Amen.
Amen.
Thank you for your time.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Madam Clerk, roll call.
Mayor Jones.
Here.
Vice Mayor Nunn.
Here.
Councilmember Dixon. Here. Councilmember Dodd.
Here.
And Councilmember McPartland.
Here.
Thank you.
All right, next thing we're going to do, are there any agenda modifications? No agenda modifications? Okay, moving on. There are no proclamations or awards. We're now going to have a presentation by the city attorney, Mr. Anand.
Good evening, Mr. Mayor, Vice Mayor, council members. Appreciate your time. I was asked to come before you to give a presentation on the government sunshine law. I've expanded it a little bit, as you'll notice in the first couple of slides. So first of all, what I've done before I even begin is I prepared a packet for all of you guys to have in front of you. So hopefully it should be easier to follow as I reference it with the slide presentation. In addition to that, by the way, that packet, I give credit to the clerk for putting it all together. Her and Kathy assisted me in putting that packet together. Right, and Kathy. That being said, it's going to be easy to follow, hopefully, with the packet, and we got more to follow. So that being said, without further ado, this is going to be what we're going to try to cover today, and I'm going to try to follow along with my slides. So this is going to be the roadmap, like we say in the military. We're going to go into a little bit into the government and sunshine law, talk about that. We're going to get a little bit into public records, more into quasi-judicial, because this is a quasi-judicial board along with planning and zoning and the construction board are the three quasi-boards we have. And then something new, as you can see new, I went over some of the specific charter provisions that might impact you guys, as well as some of the changes that we made recently in the law when we did that charter review. All right, so the first question I want to ask is, what is the sunshine law? Well, there is kind of pretty big definition. Florida government and the sunshine law, also called the open meeting law, because obviously it's open in the sunshine. It provides a right to access to our governmental proceedings as well as our process. In there, it's actually found, both the public records and the sunshine law is actually found in our Florida Constitution. So I give reference to Article 1, Section 24B, Bravo. I'm going to read it, but in your packet, you'll find it in Exhibit 5. And B Bravo reads, all meetings of any collegial public body at which official acts are to be taken or at which public business of such body is to be transacted or discussed shall be open and noticed to the public. So it's important to note that it's not only just in our Florida statute, but it's governed, and it comes from as well as our Constitution in the state of Florida. This is the main, in the military, all of us, except for you, I'm not sure if you are Councilmember Dixon in the military, but a lot of us in the military, we have that stomping your feet moment. This is one of those stomping your feet moments. This is the slide that really is the takeaway of what really Sunshine Law talks about. I've been told to stay close to the mic, not to wander too much. So these are the simple three requirements. Number one, it's got to be open to the public. Number two, reasonable notice, and that's defined by law, what reasonable notice is. It could be 24 hours, depending on what the contexts are. And minutes. Notice it doesn't say it's got to be, verbatim. It doesn't have to be a court reporter. It's just minutes need to be taken. And as you remember, keep in mind our recent history with our three council members. I'll be dismissed if I don't mention that. If you remember the facts of that case as when it came out, you had the three individuals meeting in a room. They actually made an agenda. They discussed those matters on that agenda during that meeting. And they took action on something that could have come before the board. In that case, if you remember, I was getting rid of the mayor and getting rid of the chart officer. So those are issues that could have come before the board. So because it wasn't open to the public, you recall the doors were locked, and because of the fact that that specific agenda notice wasn't provided to anybody, I heard there was minutes taken, and I know they actually videotaped the actual incident, or like they say in the state attorney's office, they videotaped the crime. So they actually had some minutes taken. But the bottom line is that two of those prongs were not provided. Therefore, it was a violation of the Sunshine Law. And this is a continuation of that. And that is when you have two or more people, in that case you had three, that they were in a meeting to discuss matters that could come before them in the future. In that case, they were actually discussing getting rid of the charter officers, which that could come before them, as well as somehow they thought they had the power of getting rid of the then city mayor, which was then Mayor Dodd. So that's pretty much those two slides are my foot stomping moment to take away. And as you see in your, I think it's Exhibit 2, if I recall correctly, or Exhibit 1. Nope, Exhibit 1. You actually have your slides with little note stains you can take. I'm going to try to keep the 30 minutes. I'm Hispanic, so I can try talking quickly, barring any questions. And if you have questions, then I can't guarantee I'll stay within the 30 minutes. But nonetheless, this is the next slide. Who is covered under the Sunshine Law? Well, the big one to me, the first bullet, and I want to cover the last bullet, but any council member, including yourself, board, commission, state agencies, county, municipal corporation, which is us, elected or appointed. Some people don't believe that because they are appointed to boards, they're covered under the Sunshine Law, and they are. Third bullet's not that important, but the fourth bullet I want to also mention to you, one person acting on behalf of the board or a commission or acting as a liaison between the board. I call this the proxies. So, for example, if you have someone, that comes to, Councilmember Dodd and say, hey, how do you feel you're going to be voting on this annexation coming on the 8th? And Dodd said, well, I'm going to vote for it or whatever. And he's, oh, okay, that's interesting because Councilmember Kelly told me that she's going to vote against it. So those are issues that now you're using proxies and they can keep talking to people. So just be careful who you share your information with. Keep it on the agenda. I'll keep it here during the dais, and that's probably my best takeaway. But proxies is another way of violating the Sunshine Law. If you recall where I'm from, Port St. Lucie, but where my previous employment in the city of Port St. Lucie had a similar issue where the actual attorney himself was the acting proxy between the mayor and getting a deal done and not sharing it with the others. And that was found to be a violation of the Sunshine Law. And of course, they were given a slap on the wrist. And we'll talk about sentencing or penalties in a little bit. So does the open meeting law apply to members elect? Let me get to that slide. The answer is yes. And of course, we have recently, actually we had two, but you've been a council member, but recently we have a brand new member to the board, Councilmember Kelly Dixon. So yes, as soon as she became elected, or notified, not sworn in, but elected, she is subject to the Sunshine Law. So that being said, sir, ahead of time, I am not picking on you. But these are little takeaways, because not only am I want to talk about the law, I want to make sure you guys understand how do you apply that law. So according to these fact patterns, you have, I'm going to step early, you have candidate Kelly Dixon is campaigning and holding up signs along Main Street. I know that because I saw her every day during the early election. Along comes Councilmember Ed Dodd, who was also there, who is running for re-election and campaigning along Main Street. He tells Kelly Dixon, at that point, Kelly, not Councilwoman, he tells Kelly Dixon all about the annexation agreement and what he would vote for. Now, that does not violate the Sunshine Law because, as I said, she's still not elected or even a council member. So that is not a violation of the Sunshine Law. Now, look at the second scenario. Now you have council member-elect Kelly Dixon is waiting for the election results at Captain Herm's. Results come in and both Councilmember Dodd, Ed Dodd, and Kelly Dixon get the majority of the votes and are elected to office. After which, again, I'm not picking on you, sir, after which Councilmember Dodd congratulates her and says, hey, first order of business is let's fire the city attorney. I wasn't going to pick on a city clerk, but I know she'll probably panic. So I said, let's fire the city attorney. Is that a violation? Of course, because now you got two members who were just elected, and that could come up in the future. So that would be technically would be a violation. I hope not, but that would probably be a violation of the Sunshine Law. All right. So now, can two members, and this is important too, because I've had some concerns actually from Councilmember Kelly Dixon came up to me about this exact slide. And I'm not sure what the Florida League of Cities is preaching or how they're talking about this. But the issue is, can you guys socialize? And I got the answer from Councilmember Dixon. She said, no, we can't socialize. I was told by Florida League of City. You can socialize. The issue is that little underlying stuff I have there, the appearance of impropriety. There's absolutely nothing wrong with you guys attending events together. Matter of fact, you guys have attended many events together, and I've been a part of it, and there is no Sunshine Law violation. The issue is you got to be careful with if you guys start talking amongst yourself, and then someone sees that, and they say, look, they're talking about something that has to do with the city. Obviously not, I know that for a fact, but that's for that appearance of impropriety. So just be careful. It's not wrong. You guys can attend functions together. You guys can even attend your own parties if you want. So just be careful not discussing city business when you're doing those things. This is what the slide I was telling you about. I was going to get to you about, what are the violations. So I think I lost my track here. 1 second. Let me catch up. So this is the violation. So as you can see, there's unintentional violation, which is what happened in Port St. Lucie with the city attorney and then mayor. Pretty much they just got slapped in the wrist. They had to pay a fine. They were done. And then you had the knowing violations. And if you recall specifically, then Vice Mayor Malti got the initial one, an unintentional violation, because he actually agreed to testify against the others, got fined. And then the other two, who no one agreed to testify, they thought they did nothing wrong, they went forward and they were charged with the knowing violation. That's why ultimately the trial pursued, and they were all both convicted of the second-degree misdemeanor, and now they're still awaiting their time. So that's actually what you can get: removal of office, attorney fees, and court costs. And I know they have a substantial court costs and fees that are waiting for them. All right, let's switch over now to public records. This is going to be pretty quick. Once again, the important takeaway, again, see my Exhibit 5, you can find it there, is the Constitution. And there it talks about on 24A, Article 1, Section 24A. Again, the point I'm trying to make is both the Sunshine Law and the Public Records Law are actually founded in our Constitution. But that being said, I'm going to read it. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, employees of the state, or persons acting on their behalf. So it is found in our Constitution, and I just want to start off public with that understanding. So the next thing we're going to talk about is, okay, well, what is public record? The Florida Supreme Court has determined that public records are all materials made or received by an agency in connection with their official business. And I got some more Q&As after this one. But made and received with their official business, which is used to perpetuate, communicate, or formalize knowledge. So the basic thing is any information that, or any public information that you receive or that you disseminate that has to do with your official business. And I want to read, which is in your packet right there, the actual section which defines it, because I was kind of shocked, and even the clerk was kind of shocked, was how broad this definition of public records is. But there it is. Public records includes all documents, papers, letters, maps, books, tapes, photographs, films, sound recording data, processing software, or other materials regardless of the physical form, characteristics, or means of transmission, and this is the key, made or received pursuant to the law, or in this case our ordinance, or in connection with transaction of an official business by that agency. And that is it in a nutshell. All considered public records subject to inspections unless there's an exception. And sometimes we do have exceptions, like when we have these bids, there's certain exceptions. Certain individuals, police officers, certain records from police officers are exempt from the public records and from being disclosed as well. All right, so what about emails? And I have questions after this one. What about an email? An email sent to and from a work or home computer is a public record, again, if it is prepared or received in connection with that person's official city business, unless, again, there is an exception. Let me get back here. Florida Supreme Court has ruled that private emails, again, private emails, does not automatically become public. It depends on the contact. Just because it's stored in a government computer, and I have some questions in it following this. So again, to be considered public record, such email must meet that definition, which is what I told you here. Again, it's right there, prepared or received in connection with official business, unless there's an exception to that. That being said, as I promised, there'll be questions. So here it is, emails or text. So emails or text, email or text the military about Joe, me, Manny and I email and I text the military about my upcoming drill on my city laptop or even my city's cell phone. Is that a violation of the public? The answer is no. Why? Because it does not relate or pertain to, city business, or in this case, city Sebastian business, public or city business. So the answer is no. It's not a public record. Just to flip to that now, email or text, again, now I'm texting the city manager, Paul, from my personal laptop or even my cell phone pertaining to the annexation agreement. And the question is yes, that could be considered public record because that does relate to city business. So I just created in my, wherever I sent it from, if it's a private email, I just made that public information as well. So you gotta be careful what you send as long as it's not prepared or received pertaining to public records. Again, that one. Anything prepared or received in connection with your business, city business. So text, what do I recommend? Should be short. As a lot of you guys know, I don't even leave messages. When I call you guys, if you guys don't pick up, I don't leave messages. Why? Because I don't want to create a record. So you guys see my number, oh, Manny called, I call him back. So I never leave messages. So again, text, if you got to text someone, make it short and to the point, something quick. And of course, avoid anything of substantive in nature. Social media, not public, obviously it's private. Meeting notes. A lot of people ask me that, and that's why I put it in here. Meeting notes. You guys have your meeting notes now in front of you. Is that considered public record because now you have it? The answer is no, unless now Mayor Jones decides to say, hey, and share whatever he just wrote on his notes. Did I get this right? This is the notes that I took. Then technically he just created, because now he's sharing his personal notes with someone else. Now it is a public record. So as long as you guys keep those notes to yourself, any of your messages, what you do, it's between yourself. The other thing about cell phone and texting, this came up. I won't say what city this came up, but this actually came up where someone in the actual meeting was texting someone on the dais things to say, and that's the rumors, but that's what I heard. So the bottom line is, texting and cell phones really are not permitted. It shouldn't even be on the dais, because of, if someone does see you texting someone, your phone might just become a public record. So just be very careful. Let me try to catch up. All right, so the next one, how long do you retain records? Well, in this case, I went to the city clerk. There is a retention schedule, and it depends on what the content of what it is. And it is depends on the content. And the city clerk, we do have a resolution. So as soon as that time frame comes of age, then obviously they properly dispose of those documents. I just wanted you to know that. So just a quick summary. Obviously, open meeting laws. Make sure during advertised public meetings, minutes taken, reasonable notice. Those are the three takeaways, and 2 or more people in having a conversation about something that might come up. Public records, again, made or received, it relates to city business. All such public records should be provided to the city clerk for retention. And the last thing, if you have any questions, feel free to reach out to myself or Madam Clerk. All right, quasi-judicial is pretty important. Like I said, there's three bodies or boards that actually are quasi-judicial in nature. That's this board, as well as construction board and planning and zoning, and actually code enforcement. And now we have a new ordinance, which now that lien reduction, if you remember, that's also now quasi-judicial in nature. So the next couple of slides, actually next 12 to 13 slides, we're going to be talking about things like what's quasi-judicial, what's competent, substantial evidence, due process, and that thing called ex parte communication. So the main thing, the Florida Supreme Court did a review and the process language on the land use in their decisions and other decisions that apply to adopted policy. The court decision dramatically changed the way you, as decision makers, look at cases. And pretty much, as I underlined there, you're acting now as a judge. And in there, in that last bullet, I talk about those boards that we currently have right now, which are quasi-judicial in nature. All right, what is the difference between judicial, quasi-judicial, and legislative? Again, you see Exhibit 2A. That makes reference to, in your little book here, actually in that 2A, there's actually an excerpt from our codes, which is 54-1-2.1, and that talks about everything that is legislative in nature and everything that's quasi-nature. But the whole thing, if you want to take away those first 2 little bullets, legislative is when you're going to implement or apply a policy. Quasi is when you implement or apply an adopted policy. So in other words, if you have a rule, or in this case we have an ordinance like the lien reduction, you guys already adopted that policy, but now we're going to implement that policy, we're going to interpret that policy, that will become quasi in nature. So if you're setting general rules or procedures, legislative, if you're going to be implementing that policy by interpreting that policy or that ordinance, then it's quasi. And again, I gave all those examples of the quasi-judicial boards that we have, and there you have that new lien reduction board as well. And that's found in 2A. So why does it matter? Quasi-judicial hearings are where decision implementing an adopted policy are considered. So like I said, like that ordinance we're going to have, once you guys implement your laws or once you implement your rules, these quasi-judicial, like planning and zoning, when they're going to interpret those rules or they're going to implement your policies, that's where this thing is considered. So you are acting again as a judge in that specific setting. The important thing is really the next couple of slides, and we're going to get more details into what they mean, but your decision's got to be based on competent, substantial evidence. Maybe a couple of you have heard me say that many times, especially during these boards. It's got to be based on competent and substantial evidence, and we're going to get into what that means. You must apply the applicable law. So you got to make sure that when you're in these proceedings, you're making sure you're applying the correct law to your set of facts, not something else. The other bullet there is due process. Due process is two things. For quasi, it's more, but the basic due process rights is you afford someone notice of the hearing and an opportunity to be heard. And we'll get into a little bit more details when it comes to quasi, some additional responsibilities and duties that you'll have, or that it goes along with it. I attached in your Exhibit 2, my memorandum dealing with quasi-judicial. So it's in your packet. And by the way, Council and Mr. Mayor, all due respect, if anyone even wants this, I was remiss, I forgot to tell you this. The clerk made this available in the board section, correct? And the board website. So any board can actually download the slides and actually download all these, what you have in front of you. And anyone who wants a copy of it, the clerk has it so they can make a public record request if they want it as well. So all this is going to be available to the public. So in there I have Exhibit 2 in your packet, which is my city attorney memorandum. I kind of updated it based on my 2020, and I made some subtle changes. So one of the things that talk about there against Exhibit A, which is the difference between quasi and whatnot. So let me go on. So the important thing about those three elements is when you have a case that is appealed, and move on to the next one. When you have a case that's going to be appealed, a circuit court has to review what you decide in your quasi-judicial hearing. They decide based on those three elements. So when the 19th Circuit looks at the matter at a almost guaranteed first tier review, they make sure, okay, well, was their findings based on competent, substantial evidence? Did they apply the applicable law? And did they afford due process to these people? As long as those three things are met, the 19th Circuit will more or less just guarantee, and we're going to get a little bit detail later on, that we actually had 2 appeals, and we were able to meet that standard. And I mentioned ex parte communication. So, moving on, this is pretty much, what does competent, substantial evidence mean? Well, you see those 3 bullets in the bottom. That's going to be the takeaway. But the evidence that is sufficiently relevant, that's the italics version, and material that a reasonable person or reasonable mind would accept it as adequate support of that conclusion. So again, it's got to be relevant, it's got to be material, and it's got to be when a reasonable person will determine, yeah, well, yeah, that does make sense when you connect the dots. Again, that's just a reference there to where that's located in your packet, which is Exhibit 2. And it's actually on page 2 of 5. So these are some examples, and this is why sometimes I harp with planning and zoning. Hey, make sure you get in our report, our staff report, because planning and zoning staff are considered competent, substantial evidence. They're professionals. They do this for a living, and that's given that kind of weight. So professional planning staffing, planning and zoning board, their opinion, that's also competent, substantial evidence. Professional experts, which I've never used here, but that's also. Sometimes layperson opinions that are fact-based on that specific issue can also be considered competent, substantial evidence. So this is what's not competent, substantial evidence. Mere statements or opinions or speculation. Someone who just wants to come up and say, well, I object, and they provide you all these documents of everyone who signed a petition. Well, that's not really in a quasi-judicial hearing. That's not competent, substantial evidence. You can give it any weight that you want. Even attorneys, when they argue, that's not competent, substantial evidence because they're representing their client in their case. Letters, document, phone calls, emails, petitions, where there can be no cross-examination by the parties. And that's another issue when it comes to due process. I'm not sure if I skipped that slide, but that's the other element of due process. Not only do you give that person an opportunity, notice of the hearing and an opportunity to be heard, but you also got to give them an opportunity to bring in witnesses and cross-examine witnesses. I hope that slide's coming up. So next slide. Next slide is, must council, board, or commission make a finding of fact? Legally, no, but I like it because it's cleaner. So that's why I say, however, yes. So legally, you're not required to, by law, to have a specific finding of facts based on the facts. But practically speaking, when you're hearing all these matters and people are applying all these facts to this case, you're basing your competent substantial evidence really upon those facts. That's what you're basing it on. So that's why I say that. And usually, it's the one that when you do it that way, it's really difficult to overturn these kind of appeals when it goes to court. And that's a little note I put there in the back. So even though it's not required, a hearing record that includes a finding of fact based on competent substantial evidence are less likely to be overturned. So this is my recommendation about findings of facts. During the discussion and deliberation portion of the quasi-judicial hearing, the council board is strongly encouraged to discuss the evidence in the testimony. Because sometimes we have the tendency when we're on the board that, you rely strictly on the reports given to you by the competent substantial evidence. But look at those things and then base it on some, and we tend to help you along that process. But read it and discuss that evidence and testimony. Those are your facts that you're basing that competent and substantial evidence. Again, look at page 2 of 3, actually 2 and 3 of page 5. So, presented as it relates to the codes, ordinance, or criteria code, that's the law, based on decision upon specific fact-stated findings. The last thing is important because I, as the attorney, ultimately draft up these final orders. So in these findings of facts, they should be recited in your motion, which you guys usually do, or your decision, or your magistrate, so that then I prepare my order, and ultimately it's signed by the mayor, and it's filed with the court. Okay, so what is due process? And this is where I'll tell you additional requirement. So due process means, like I already established, you got to get a person notice of what's going on and opportunity to be heard. All that is found on Exhibit 2, page 1 of 5. Quasi-judicial hearings meet the basic process requirement, which is the notice and the opportunity to be heard. But there you see the additional things that we have to do when we're having these quasi-judicial hearings. You have to allow them to present evidence if they so choose. They don't have to, but I'll give them that opportunity. Any evidence to prevent? No. Okay. Put it on the record, when the applicants come here. Do you have any evidence you want to put forward? Yay or nay? Okay, record's clear, no evidence. Give them an opportunity once the city goes and they put on their case. Give the applicant an opportunity. Do you have any questions for, whoever that was? Give them that opportunity to cross-examine. They might not want to, but nonetheless, give them that opportunity so that the record is clear that they were given at least the opportunity. Also, another key thing is, Madam Clerk, as you know, when we get into these meetings, the witnesses have to be sworn to testify. You guys okay so far? All right, good. I think I'm doing good so far. All right, so this is another thing you guys have heard, ex parte communication. What is ex parte communication? Well, there it is. It is a communication made outside of the hearing and off the record. That's why it's ex parte. Such a communication could make your final decision with the presumption of prejudice. And there's a little example. That's just like if someone is appearing before the judge and they previously are talking to the judge about their case right before you go before the judge. You could be thinking, wow, that doesn't sound right. Why is that person talking to the judge and now he's before the judge? Same principle. Ex parte communications includes all forms of communication, investigation, site visit. And the reason why I underline those two things is you'll see eventually when we get to your codes that you guys do have an opportunity to actually conduct your investigation and do site visits. So if you do that as part of your investigation, you need to disclose that in your ex parte communication, that you actually went out, you did a site, you did your own investigation or whatever. So that's why I underline that, and you'll see that a little bit later on. So again, what's bold there, the safest course of action by you guys, the decision makers, the judges, is to avoid any ex parte communication. Just say no. Don't, unless you guys have to talk to them, but simple way is just say no. That way you protect the process. So their ex parte communication must be disclosed by the council or the board before or during the hearing, during that meeting. So you got to disclose that stuff. And there, Exhibit 3 in that packet that I prepared and the clerk assisted me, there you're going to have her form that you guys have to fill out. So at least it's there. Now you know that if you have any of these things there, communication includes you communicated with them, investigation, site visits, expert, make sure you disclose that. Same thing with because the case law is kind of weird on this one. I actually had to ask some opinions about this, but even communication, remember, you guys are judges, so think about you being in the role of a judge. So even if you have a communication, not with me, the attorney, but if you have a communication with staff on that matter who's going to present that case, disclose that as well. Because just like a judge in a matter, any inkling like that, and I had to ask it around. No, there's a case law that talks about that, but I could not find it. So I got some overwhelming support that yeah, you should err on side caution and disclose, even if you had communication during those quasi judicial hearings, even with staff, just disclose it. Again, that form is found in Exhibit 3 in your packet. Thus, providing an adverse party, this is what ex parte talks about, once you give that form and you write that, hey, you know what, I did do this, now you've given that adverse party reasonable opportunity to confront, refute, respond to, and or rebut any such disclosure to prevent that appearance of impropriety. Again, there is Section 2 now, B as in Bravo, there is specifically now the Florida statute section, which talks about ex parte communication. So, and the fact that you're giving them the opportunity to rebut the stuff. That's why I quoted that. So, again, ex parte communication, just make sure that if you have it, make sure you disclose it during the meeting. Okay, is there a quasi special way to conduct a meeting? The answer is yes. Again, you'll find in your Exhibit 2C as in Charlie now, you'll find what council did back in 2020, which was Resolution 2035, and which was reestablishing all the procedures for quasi judicial. And it's pretty in-depth. So again, I attached it, so you guys can feel free to look at it. Any questions, let me know, and I'll be more than glad to fill you guys in with that. But that was the decision that you guys, the council, made as a body, and it does go through that order of proceedings of what you have to do when you have conduct, meaning, call the order, read it, and all that order, you go first, you go second, all that order is specifically spelled out in the resolution as well. All right, here's a summary, and then we'll move on to fun things. I'm just kidding. So here's a summary. Again, decisions to apply what you guys have already adopted when you're going to apply your law, that is quasi nature. Proceedings quasi, we do have a resolution which establishes what that is and the order, the pecking order of what you have to follow. Your judges, you're acting as judges. Again, talks about competent substantial evidence, and I didn't go into that previously. But the reason why that's important when you're competent, substantial evidence, applicable law, and due process is we were actually have been appealed twice with our boards, and thank God that we did things correctly. We do provide our board with competent, substantial evidence. The applicable law is what it is, and they did apply it. And these people were given due process. We've been appealed twice. Once in the construction board, and they came back in our favor. And the other situation, if you recall, with Damien, when he appealed his code, that also came back in favor of the city when it came to that appeal. So those are two decisions. Since I've been in 3 years, we've only been challenged twice under me, and we've successfully won that at the 19th Circuit. All right, so and ex parte communication, you guys know. All right, so now the other thing I want to talk about, quickly as possible. We have a little booklet, as you guys know. This is the old version of it, and I'm going to get into where we're at with that at the end of this presentation. So what I did, all of this, I attached to your Exhibit 4. So what I'm reading on these slides is right on. I've made it in yellow, so it's really easy for you guys to follow what we're talking about. So what I did is I kind of broke down, not all of them, but some of the key provisions of our code, so that you guys can have an understanding of where we're at. So one of the main changes that we made, of course, now is a year residency requirement. That's at 2.02. Terms of commencement Terms of newly elected council members shall commence when they are sworn in immediately prior to that first regular scheduled city council meeting held following that certification. So as soon as that happens, that's when your term begins. Duties of the mayor, I wrote some down there. Mayor shall preside at each meeting, city council. He has a vote, but notice there in yellow, he doesn't possess a veto. He can overturn anything. Second bullet there, mayor shall have the power to declare a state of emergency. Now it's clear. That also made some changes to it. He does have that power to declare a state of emergency, preserve the peace, and be recognized as the head of the government. And finally, of course, he signs pretty much all ordinances and resolutions. So this should be quickly. Vice mayor, in the absence or in the disability of the mayor, of course, he steps in. That's pretty much self-explanatory. Vacancies. Make sure, because I think I don't want to miss anything important. Vacancies, in the event an office of the mayor shall become vacant, of course, then vice mayor fits in. If the vice mayor and the mayor, then of course you go next to the most senior person on the board, they get sworn in. Now, general powers. All powers of the city shall be vested city council. Of course, there's some exceptions, so we'll get into that in a second. But so pretty much all the power is vested in you. But read there, except as otherwise provided by law or in this charter. And there is some exceptions, which you'll get into when we get into the city manager's part. So yeah, all the powers invested in cities on you guys, except that was already given by charter to the city manager. 2.08 talks about vacancies in Exhibit 4. And let me really quick. That one is important because if you recall, that one there's some changes to it drastically. Let me look at it really quick. So now we have in there a section that says if you're convicted, obviously crimes of moral that's always been there. But when you see the bottom part when it talks about Section C in your packet, suspension from office. So now we included or for misdemeanors related to duties of the office, which that wasn't there previously. So now we have it. And in addition to that, now we have a process that's built in case that does happen, because before we didn't have any teeth in the charter, and now it's built in that there is a hearing now. And of course, city council, with the advice of city attorney, will hold a special hearing to consider the vote to remove or suspend a charter officer. I just want to bring that to your attention. Those are some changes as well. City council relationship. Again, city council nor any of its members shall dictate or appoint or remove any city employees except the charter officers. City council nor any of its members shall give orders to any employee. I know that's been an issue sometimes. So an order to me is like you're directing staff to do something. Having a conversation with staff, talking to staff about something that's going on in the city or issues now, that's not directing staff to do something. So just make it clear. If you have a question, like some have come to me and we'll talk about if that's the issue. But just don't direct staff. And I'm going to give you an example where I was back in PSL. If you're driving down the street and you see like a down sign and the mayor calls and says, calls Public Works or calls Brian in this case, says, hey, Brian, you need to go out there and pick up that sign like right now. Because the sign out there and order him to pick it up. That might be one of those crossing the sign. You might want to call a city manager and say, hey, I just saw a sign, order him to do it. Is probably the clearest way to do it. All right, 211. 211 is the investigation. Remember, I was just telling you guys that you guys have some authorities, and here it is. You do have a right investigation. City council may make investigation into the affairs of the city and the conduct of the city departments, office, or agencies, and for the purpose, they may actually subpoena, which was kind of interesting reading that. You can actually subpoena witnesses, administer oaths, take testimony, and require the production of evidence. So that's pretty strong. Let you guys know you guys have that authority vested in our charter, which is our law. 212 talks about topics. This is also one of the changes that we had, specifically dealing with special meetings. The biggest takeaway is that, yeah, you can still do it. Anyone can have a special meeting, but now we're limited to that one topic. And, of course, everything else still applies. Voting may be by voice, except for, obviously, appropriations and ordinance and things like that, of which affirmative votes of 3 or more will be required. All righty, emergency ordinance. This is this the one I have? Yeah. So emergency ordinance. This is not to be confused, and also I have it in your exhibit behind Exhibit 2 Bravo, behind that the section dealing with the public records. Sunshine Law. Behind that, you'll see Florida Statute 252.38, which is a different section of the law. But understand that you guys there is a right for public ordinances for public emergencies affecting life, health, property, or the public peace. If you're going to have one of those ordinances, it's going to require an affirmative vote of at least 4, so supermajority vote, to get those ordinances passed. And the reason why I mentioned that other section, because there it says it shall automatically stand repealed on the 91st day. And you're going to say, well, hold on, we just had something that was, you can't go more than 42 days. Well, that's the other section which I added to the Exhibit 2B, which is 252.38, and that's talking about when you have this emergency ordinance like what we had recently with the hurricane. There we have to do it every 7 days. And every 7 days you got to, again, re-up it. And the maximum you're allowed to do is up to 42 days. And we haven't gone beyond that, but I think we have Paul and I have a resolution. City manager and I had a resolution that even if you get beyond the 42 days, I think we could still hang our hats on the actual declared emergency by the governor. So it shouldn't be a problem to continue with the emergency. Appoint or removal of charters. I won't even discuss that one. No, I'm only kidding. You guys have a right to remove us for cause, without cause. And when you look at the section 3.024, it details exactly what you can do. The bottom line, if you're going to get rid of us without cause, it's not a problem. You say, for whatever reason, 3 of you say, you know what, Manny, you're done. I appreciate your service. Thank you very much for everything you've done, but we're going to go somewhere else. And then you're going to let me go, but without cause. And of course, there's going to be some money involved, and then we go on our way. I think it's X amount of money by statute anyways, and we go away. But you also have an opportunity if it's with cause. And with cause, it's like a hearing. You're going to have to give the person, meet with them, give them the charges, give them an opportunity to prepare, an opportunity to have a hearing, and then goes before you. And that's in the charter in 3.03 or, let me see, 03, there you go. 3.03 talks about that. All right, so the next one are your 3 chartered officer. The city manager is too long, so I'll go into that one. City clerk is simple. What she does and what I do is simple there as well. City attorney shall serve as chief legal advisor to the city council and departments, office, agencies, shall represent the city in all legal proceedings, and shall perform the duties prescribed by the charter and ordinance. The reason why I highlighted the other stuff is that you guys understand is that you do have the authority for those special occasions like we've done in the past, is to hire additional counsel to assist us in those specialized matters. Back to the city manager, it's just too long for me to write. I just prefer to read it. But you'll see it right there in your Exhibit 4 on page 10 of 18. You'll see all the authorities given to the manager. Remember, everything is vested in you guys unless it's what's otherwise given by the charter. So first one, city manager shall be the chief administrative officer of the city. We all know that. B talks about he shall appoint, suspend, demote, and dismiss city employees. That's why you guys can't do that, only us. He has the authority to do that. City manager shall direct and supervise the administration of all departments, except my office. He cannot direct me, and he cannot direct the office of the city clerk. He shall attend, obviously, council meeting, which he does. City manager shall obviously faithfully execute all the laws, all the ordinance. That's also in D as in Delta. We know he has the authority to do the budget. F talks about designating someone qualified city employee to exercise the powers to perform the duties of city manager during any temporary absence or disability. And I thought it was pretty interesting, the very next sentence. I didn't know that was there. But actually, city council has the power to revoke such designation at any time and appoint someone they believe is eligible, but it can't be one of you guys. And the very last thing there talks about, what the manager, as far as signing contract. Of course, we all bring everything to you guys, and he ultimately signs all those issues. And I think that is it. I am hoping pretty close to 30 minutes. So this is some of the basic takeaways. I didn't want to talk about all these other sections because I didn't think that's that important, but it is in your packet. Article 4 talks about the election, filing for candidate, any issue with that, canvassing board. I learned what a canvassing board was when we had the special election with the recall. Procedures, interesting about tie votes. Before it was kind of weird, now it's by whatever the law says. Talked about entering government. So if you're interested in that, that's in Article 4. Article 5 are more of the general provisions. There, Article 5 is where you have the charter review, which I was a part of with the clerk as what were you? No. Yeah, charter review, yes, right, with the clerk, and also the city manager who was assisting. That was a fun time when we were doing that charter review. 15 people trying to agree to something. It's kind of interesting. Anyway, that being said, Article 6 is the transition, and this is what I want to tell you. I'll leave you with this. Update on the pamphlets, because I know some of you guys have asked me about where we're at with the pamphlet, why don't we have it? Well, first of all, Muni Code did a really, I think I shared it with some of you guys, did a really cruddy job, and I don't want to bash them, but didn't do a very nice job putting the packet together. It doesn't look like this anymore, what they were going to give us, which is nice. So when they offered us the proof, it was like almost, it was 4 by 6, and it was staples. The corners were staples. So it looked kind of unprofessional. I know this is not official, this is for informational purpose, but I want to look more professional. So when we saw the proof, we didn't like it. So then we went to another company, ABC Printing. They had a really nice proof. It's going to look just like this, just same size, same thing. Thing is going to be, what's it called, blue? It's going to be ice blue, because I didn't know it was true, but apparently there are shortages of paper. So it's going to be ice blue. So it's going to be nice. I know Paul says it's his favorite color. Blue is my favorite color too. So it's going to be nice. And we are still waiting for the proof, correct? So we're still waiting for the proof. But once the proof comes in, we already agreed to the quote. It's way under budget, like $1,400 and change for 500. And once we get that, I think it takes about a week or two to get us to 500 copies. So I'm kind of excited about that. So other than that, Happy New Year's. Any questions? I think, something else we're doing, obviously we're recording it, and this will be part of on the board. We're gonna take this piece. So if you guys have questions, feel free to ask. If not, I got nothing further.
Thank you so much.
All right, thank you.
Thank you.
All right, thank you so much, Mr. Nunn. I think after sitting here for 30-plus minutes listening to an attorney, I think we need to take a 5-minute recess and then come back and start the business, because I can't focus now.
Well, he went 38 minutes. I think we should go back to 3.02 and 03 on the...
So we're going to take a short recess, 5 minutes, and then we'll resume.
I tried.
Thank you.
I tried.
Ms. Vice Mayor Nunn, could you take care of that for us, please?
Be honored to. January 16th, City Hall will be closed in observance of Martin Luther King Day. Also that day at 10 a.m., our Sebastian River High School band will be marching in the Gifford Martin Luther King Parade starting at Gifford Middle at 10 a.m. So if you're off that day, give it a shot. January 14th, we have the Craft Club of Sebastian at Riverview Park from 10 a.m. to 3 p.m. Fellsmere Frog Lake Festival, starting January 19th to the 22nd. Sebastian Fine Art and Music Festival in Riverview Park on January 21st and 22nd. And that is our announcements.
All right, thank you so much for that, sir. We're going on to public input now. Is there anyone from the public here who would like to speak on anything that's not on the current agenda? Please step forward, give your name. Seeing none, is there anyone on Zoom? None? All right, moving on. Consent agenda. Council, what's your pleasure?
Move approval of the consent agenda.
Second.
Or do you want to pull
I
something?
apologize, Mr. Mayor.
You want to pull
I would
something?
like to pull item 8B, please.
Yeah, sure, absolutely.
Okay, so move approval of item A and C.
Second.
All right, so we have a motion and a second on approving A and C, with B being pulled. Any discussion? All in favor, signify aye.
Aye.
Any opposed, like sign? Motion carries. Item B, Vice Mayor Nunn.
Yes, Mr. Mayor, I just wanted to bring that up. Obviously, it's a large purchase of $20,000. It's a purchase of a couple drones, and I would ask the city manager if we have anybody that could help us understand what the drones are for and the purpose. It'd be great.
Yeah, Vice Mayor, Mayor, members of council, this is a budgeted item that we had in the budget. It is a tactical use for the police, and obviously we don't want to get into those uses, but I have the chief here today that can kind of go into some detail and not expose our tactical use of why this is important for the safety and for also for rescue for our residents.
That'd be great.
Chief Acosta?
Good evening, Chief.
Good evening. So I have some notes here. If you don't mind, I'd like to just, it's
Yes,
a
sir.
statement I prepared just to explain the advantage of drones and what they would be for our agency. Excuse me. So obviously drones are unmanned aircraft. They're portable and easily deployed in rugged environments, which increases the safety and the response decisions for responding officers. As you know, we have the North County Preserve, the Stormwater Conservation, the preserve behind Pelican Island Elementary, you know, among some other ones in the city. Sorry. The following are some situations in which a drone would be beneficial for the police department. So for field deployment, immediate situational awareness for officers on a scene. During perimeters, one drone pilot can replace several officers that are needed to observe an area, you know, several different corners where we typically would need an officer at each corner. You could put a drone up, one drone pilot could watch several corners at once and allow the other officers to either search the area or respond to other calls that we have waiting. Search and rescue operations for searching for missing endangered adults or juveniles. Broad surveillance at parades and our park events, and tactical deployments. Drones can operate in obstacle-rich environments where a view from above would obviously be advantageous. I just want to cover a couple real examples that we've dealt with recently where we could have used a drone and it would have helped. Not too long ago, we had a boater shoot at other fishermen at nighttime, and obviously deploying a drone to get out over the water and over him to view what was going on in the vessel before we got there would have been safer for our officers rather than just approaching by boat and having to deal with this guy by boat. We've had domestic violence
Chief,
incidents.
can I just mention one thing?
Yes,
In
sir.
that case, the sheriff's helicopter did deploy and did get there and took fire. So now you have pilots at risk. In that case, in this case, it would not have put a pilot and co-pilot at risk.
Thank you.
Right, and obviously if we had a drone, we would have been able to, you know, deploy it a lot sooner to keep an eye on the guy rather than have to wait for the pilot from the sheriff's office to get out of bed and go to the
helicopter, get it up and things like that, but, we've had domestic violence incidents where a couple will be fighting or arguing or get into an actual physical altercation. Half of the couple will retreat and take off, call law enforcement, and then we have to go and respond. And if, in instances, we've gone and we have to treat that, you know, if the other half, whether it's male or female, doesn't respond, we have to treat it like a barricaded subject. Even though the half that retreated allows us to enter the house, it would be much safer to send in a drone to get a view, because a lot of times the other half, if they're intoxicated, have passed out. But we spend several hours waiting to find out whether they have or haven't, and we can also see where they're barricaded or how they're barricaded or what surprises they have in the house for us. In the event of a foot pursuit into a wooded area, escaped prisoner, something like that, the same thing. There's a perimeter involved. There's also, one of the drones is equipped with thermal imaging, which can search the area for heat signatures and find them a lot quicker than we can pulling all of the police officers off the road and trying to search a wooded area. You know, this obviously would speed that up and assist in accomplishing that in a safer manner. And then, like I mentioned, the locating missing or endangered adults, we've had that several times in these preserves that I named. We've had people that, whether they go for walks or, you know, go out there unknowingly, especially in the summer in the bad heat. We have had some people that have passed away, and, you know, a drone could help us find them faster before that happened, or, you know, find them at all, and it would definitely assist in that manner. The thermal drone, which is the more expensive of the two. So like I said, those are incidents that we have actually dealt with here and even recently, and most of those we deal with on a regular basis. And, you know, with, you know, I think without a doubt, having a drone would have helped us in those instances.
Awesome.
So, anybody have any questions for me? Or?
Yeah, I do, if I can, Mr. Mayor.
Yes, sir.
So we have licensed or trained drone pilots now on staff?
We do. We have, in preparation to purchase these, we have sent 2 officers that are, have gone to training and are getting their licenses. Yes, sir.
Perfect. Awesome. Thank you.
All right, yeah, thank you so much. Any other questions from council? Hearing none, we'll entertain a motion.
Yeah, I'd like to.
Thank you, Chief.
Thank you.
A motion for, to approve item 8B. Thank you.
Second.
So we have a motion and a second. Any other discussion? Madam Clerk, can you call the roll? This is a money item.
Yes, sir. Councilmember Dixon?
Yes.
Councilmember Dodd?
Yes.
Councilmember McPartlin?
Yes.
Mayor Jones?
Yes.
And Vice Mayor Nunn?
Yes.
Motion carries. Thank you.
All right, thank you. Moving on to committee reports. Anyone have any committee reports? I don't have any from the Beach and Shore line yet. We just received a lot of information that the state sent down, but we haven't had a meeting, so it's coming up.
One thing I would like to ask as we move into this next section, and I know things used to be more like this, and I think we kind of went away from it recently, is that when we open up a new position, as we're going to enter into A and B, is it a possibility that we offer up to let anybody that's running for a position come up and speak before we make motions?
Absolutely.
Give them opportunity to, and it's at their choice to do so, it's not required, but to give an opportunity to say, here's why I want the position, here's, you know, what I'm thinking. Does that sound reasonable?
No, I'm fine with that. Absolutely.
Okay. I know it's not something we've done lately. We just kind of jumped right into motions, and I know there are other people that would have liked to have had a chance to say something. And so I think that gives an opportunity for all to be heard.
All right, so are there any other committee reports? Hearing none, we'll just go ahead and move right into item A, Citizens Budget Advisory Review Board. I think we have, what do we have? What page? 38. So we have, oh, I'm sorry, Councilmember Dixon.
Yes.
I would like for you to go ahead first because yours hasn't been announced yet. Have you
Correct.
made a decision on who you would like to appoint?
I have.
Let's hear it.
I would like to reappoint Bruce Hoffman.
Okay, Bruce Hoffman is Councilmember Dixon's choice for the Budget Advisory Review, so we can take him off the list for the, and next we have, I think we have 2 vacant positions that we need to fill, so I'm okay with motion or nomination for one of those.
I'd like to reappoint Amber Serta to the board.
And, I'd like to reappoint Dave Newhart, although he's on a cruise, and that's probably a good reason not to do it, but.
All right, so we have the 2 vacant positions. Is there anybody else with another name?
I was also gonna, say Dave Newhart.
Okay, good. So we have the 2 positions, and I don't think we need to do anything on that because those are the only 2 chosen, correct?
Well, since there's 3 applied, do we actually have to vote, though?
There was only 2 nominations.
Well, but there's 3 names on the list, should we not? We should probably.
Yeah, but only 2 were chosen.
Okay,
Yeah,
all right,
yeah.
okay, yeah.
So only 2 were nominated. If there were 3 nominated, then yes, I think
Okay,
so.
good.
Mr. Anand, is that correct?
Yeah, I think by acclamation, the 2 that were appointed, since there's nothing else, they should get the position.
Thank you. All right. Next item is B, Indian River County Citizens Oversight Committee for School Planning. I believe we have 2 applicants for that.
Yes.
Are any of the applicants here?
I know,
Who do we?
if I may speak. I
Yes.
know one of the applicants is at the school board right now at their meeting they have this evening.
Okay.
Okay, Mr. Mayor, I'd like to nominate Christopher Roberts for that position.
Okay.
I second that.
I would like to nominate Jennifer Pippin.
Jennifer Pippin and Christopher Roberts. All right. So we need to have a vote. Yes. Madam Clerk?
Councilmember McPartlin?
Actually, sorry, hang on. Before we get started, is any of those Jennifer Pippin or Christopher Roberts in the audience? No? Okay. All right, we can go ahead.
Okay, Councilmember McPartlin?
Christopher Roberts.
And Mayor Jones?
Christopher Roberts.
Vice Mayor Nunn?
Christopher Roberts.
Councilmember Dixon?
Jennifer Pippin.
And Councilmember Dodd?
Christopher Roberts.
Okay.
All right,
Mr. Roberts.
we have that done. No public hearing. Unfinished business, discussion on the purchase of similar properties located at 1527 and 1528 Indian River Drive. Mr. Carlisle.
Yeah, Mr. Mayor, members of council, the council had given me direction to work an offer up on the properties mentioned on Indian River Drive, owned by Sembler and Sembler, which is next door to Fisherman's Landing. That property they had given a asking price of $2.9 million, and I had looked at properties up and down the river, and I had given them an offer of $1.2 million, and so they had counter-offered at $2.5 million. And so when I look at the properties up and down the river, they may be comps that they have available or properties listed to get them to the 2.9. Our challenge is, we have a statute that dictates how we buy property, and it has to be, if it's a certain value, we have to get 2 appraisals, and you can do an average. But in no case can you go over the appraised amount without a supermajority vote. Our charter says supermajority. The state statute says extraordinary vote of council. So for me to go any higher than what we've offered, basically would have to be a unanimous or 4-to-1 supermajority vote of council. And I've given you some examples of properties I looked at that sold in 2022. One that points out is Arlo Guthrie's property. It's a huge piece of property with a huge house on it, and it sold in 2019, I think, for 1.9. And so and this is vacant property with a dock that has some challenges. The dock has some challenges with the aquaculture. I did talk to Florida Department of Agriculture because the lease says if the property is sold, then the improvements need to be removed. That's the clam farms and the oyster farms. And I had talked to Florida Department of Agriculture, and if we assumed the lease, if we were to purchase the property, then they felt confident we could assume the lease. And then I had a later conversation with them, and I would assume that someone else could assume the lease as well, because it really was a renewal of an elderly lease. So they were taking it, it's been in place for 10 years, so the 6 years may not be such a problem regarding someone else managing that lease. The problem is if someone buys the property and they want to remove the aquaculture and they want to store pleasure boats on there, that raises a whole nother concern with Department of Agriculture and the funds that were expended to put those improvements in, they have to be removed. So when we look at that property, we want the property because we want the view and we want the dock, we want the aquaculture to stay, but we have to look at what the value that is. And so, you know, we ran some numbers and they've been changing a little bit on the financing, if we were to finance that property, and it just gets expensive. And, you know, if we use $500,000 out of DST or $500,000 out of as a down payment out of the CRA, it leaves us like $58,000 in the CRA budget. It's just something I need direction on. How do you want me to move forward, you know, financing that property? And then it's going to be a challenge for us. We've got a lot of things coming before us.
So is there leeway based on the law? Like the two that we have, the two estimates that we have, you can take the average of the two and go 10% above or something maybe? Is the max?
Well, so
You can go to about
So
one.
let me put it this way. So the appraisals are not public record unless you all want to make them public record.
Right.
So I need to know that if you all, you all have to decide whether you want to make them public record, and then I can address them.
Would it be safe to say that your offer was what you considered to be the top that you could do without council override?
So I could go to 1.5. It would be the max I could go to.
Okay, without council override?
Without council approval.
Okay. You know, in looking at the numbers, I even went crazy enough to do a little spreadsheet based on all the pages you put in here because I was trying to figure out what those pieces of property were. There's the stuff that's sold down there. Arthur Guthrie's house sold for 1.85 in 2021, actually, 1.85, and there was one that sold on Indian River Drive for 2.8. It's 2.84 acres, and it happens to be the piece of property that the county is going to build 13-building hotel on. So I'm not so sure that having approval to build a 13-building hotel on it drove up the price quite a bit, or it made the person buying it being willing to pay more money for it. And with the legal ramifications, I mean, I personally would love to have that piece of property.
Me too.
I just don't think we can pay that kind of money for it. My personal opinion would be, council, that we continue to try to find grant money if we can, to see if we can extend the working waterfront some way or another. I don't know whether there's working waterfront grant money still out there. So we try to find some grant money, and if the city doesn't have to come up with 2.5, but we can use grant money to make up the difference, it might be worth the city thinking about doing something with that. Mm-hmm. I also personally, I went down there again and looked at it. I was just thinking kind of the visionary thing about what could we do with that piece of property on the west side of Indian River Drive to enhance the working waterfront, not make it necessarily part of it, but to enhance it. You know, put some type of additional facilities in there, put the museum in there that we're supposed to have, that we're going to have a problem with when we redo that building that Hurricane Harbor is in, you know, and some things like that. So it might be worth doing. I just don't personally think we can pay that kind of money for it.
I agree. I don't want to overspend, and I don't want to lose that property at the same time. Because once we give it up to somebody else to grab, we're never going to get it back, and we'll regret that.
Yeah. So,
Yeah, no, go ahead.
So obviously, the property is a very, very perfect location to expand our existing working waterfront that already has aquaculture, which also keeps the history of Sebastian alive with the fishing history. But the cost, I agree. I mean, if we could find grants to help offset that, I'm not comfortable with spending that kind of money and using our reserves and all of that. You know, if we could take the waterfront side of it to keep a hotel or a huge house to be from being built there, and then even sell the other side of the road, I would be okay with discussing that, but not at this cost. I just think we have to find an easier way to get that to where it should be, even with grants, in my opinion.
Yeah, no, I'm really torn on that because the aquaculture business there is very important to our lagoon, and even expanding that to help assist that lagoon to stay healthy. I would love to be able to say, let's buy the property, but that cost is too much. That's not fiscally responsible for us to even look at it at that point. Perhaps we can get some more negotiations going, some grants or whatever. That would be wonderful, but it's just too much for me. Mr. McPartland.
I wasn't willing to go to $1 million to buy the piece, I mean, it's a beautiful piece of property. I'm willing to put $20 in and play Powerball tonight, and if we hit, then I'll buy the property and the city can have it.
Yeah.
But, I mean, we gotta get out of the business of buying the property. I mean, maybe all that money we approved to, buy $50 million worth of property in this county, maybe the county could come down and buy that piece of property and keep it preserved.
Yeah, or maybe some of this new money that the governor just signed yesterday.
All right, so I guess you have a consensus.
Do you have any COVID money? You know, they signed a resolution, the federal government made a decision yesterday that you can use your leftover COVID money for this kind of stuff too.
Yeah, we don't actually have.
Do we have any of that left over?
No, we've spent,
No.
I think we've had maybe $20,000 or something.
Yeah,
We don't have
wouldn't
a lot.
help.
But just to answer your question, Lisa and I have had a pre-meeting with DEP on expanding the working waterfront for additional boat stop, parking. And we met with, the engineer, and he's gonna do a preliminary study and see where we're going to find out what we can do to expand the boat parking and do some aquaculture on the side of that. And so we're working on that as we speak.
That's at Fisherman's Landing?
That's at Fisherman's Landing.
Okay.
You know, anyway, we're on this topic today, so let's, I appreciate your input,
Yeah.
and we'll move forward.
All right, so we'll go ahead and move on to so you're comfortable with the direction we're given, correct?
Yes.
All right, so we'll move on to item B, discussion of stormwater codes related to the building of newer homes on adjacent existing properties. Mr. Carlisle.
So this is something that's plaguing communities all over Florida. It's not a new challenge. The way to deal with it is not something that has been people haven't been able to find a way to do it. And there's a couple challenges you have is you got homes that were built under one code, as we know, and you have a home that's built under a different code. So you know, you have different circumstances. Not every circumstance is the same. Everyone is as unique as the development that it's in. So you have one home that may have been built and it was draining into a vacant lot. And now that vacant lot is built. You're no longer draining into that vacant lot. So the new home isn't draining on you. You're just no longer draining on them. And so that creates that drainage issue. Yards get changed over time. People plant trees, they plant things, they put things in their homes that don't allow the water to move forward, but it still went into the adjoining lots. That adjoining lot gets built, that doesn't happen. So we know these problems exist, and then you have the challenge of, does the city go in and work on private property for a private property issue? That becomes a challenge. You have issues where a homeowner changes their topography that affects another homeowner. There's a city to go in and fight that battle. We had it with this one individual that had been to the city a couple different occasions. We worked out with the property owner that's building behind them to allow that water to go through that property, which is not normal, but the builder was willing to do that. The problem with that one is the property adjacent to it meets all the codes, and the city went to the builder and said, would you be willing to regrade that yard? And the builder said, absolutely. The homeowner said, absolutely not. That's the information I was given. So now you have two homeowners at odds because this homeowner says, my yard is correct. There's nothing I need to do to my yard. It's not my issue. And so, you know, we've looked at the Martin County Code, and it doesn't give much more direction than what ours does. Ours says you can't adversely affect. Well, me building my lot to code, if it adversely affects a lot that's not to code, is it that builder's responsibility? You know, I've talked to Manny about it in the past, when this first came up, and how we can address it, and, you know, what can we do? Can we make a contractor go in and survey the yard next door and say, okay, that's what has to happen to that yard so that when I build my house, it doesn't affect that yard? How is that going to be incumbent upon a builder to do work on adjacent property? And how do we do that? And this is going to be a hard decision to make, and how we do it, and individual property rights are affected. So I'm open to suggestions from council, but, and Karen, our city engineer, she's been beating her head against the wall and been working very diligently with this resident that has this issue. And it is not an easy fix. It is not an easily one. I know the answer that most would like to say is just don't let them build on those vacant lots. Well, those vacant lots have property rights too. So, some of this that's just not doable. We're gonna have to look at it, and maybe when we do our site inspections, maybe we can talk to the contractor about making some concessions in their plan through our engineers that do the lot inspections. But if they say no, we're following the code and we're following this, and because if we do it this way and it creates a problem, then we're reliable. So it's a circle, right? There's no easy answer. And we're not stopping looking, and we're not just saying, hey, if we throw our hands up, we can't do anything. That's not a good position to take either. But it's a complicated one, and there's a lot of moving parts, and everyone is different, and they need to be addressed on an individual basis, I believe.
Right. We have that in our land development codes.
Could you, Mayor?
Sorry. We have that in our land development codes, pretty much. Property grading shall not inhibit drainage of other property. Stormwater runoff shall be directed through a proper system, including driveway, culvert. Property grading shall not inhibit the drainage onto another property. We have all these things in our code. Are we looking at them up front when they're starting to build these houses before they're signed off on with the graded slopes and everything?
But the challenge you have is there's two parts to that. They're required to build their drainages to drain their water into that system. Where the challenge comes in, you're reading it can't inhibit the other property. Well, the other property is creating the issue. So this property owner is going to have to accept the water from the undeveloped property owner. Now you've violated their property rights because this property isn't graded properly to drain. It's draining onto my property. And so if you're draining onto my property, I am now, based on what you just said, when I build my house, I have to continue to accept their drainage, even though their property isn't graded properly. And that becomes one of the challenges. So I basically have to give up my property for my neighbor because their property is not graded properly. I'm not saying no, I'm saying how do you make that happen? And I don't have a good answer right now. I don't.
The extremes are gigantic, all the way up to, there are many places in Florida where, period, you cannot let a drop of water come off your lot. I don't care why. I mean, I think I gave you an example when I was talking the other day. I watched my brother's crew put in underground cisterns to hold water from downspouts from gutters in Fort Lauderdale because you couldn't let your downspout run onto your lot so it could potentially escape someplace else. Condensate, not unusual at all, put cisterns under the ground for condensate from air conditioning systems to do that down there because the same thing applies. So extremes. I personally think I know it's a complicated issue, but the simplest thing to say is it's the existing resident's problem. And I know you're not saying that, but what happens when we start talking about it and we start talking about, well, the guy who was there, maybe he was draining differently than he should be draining. Well, if the cost of building on a lot, to me, the cost of building on that lot is not any different than the cost of a developer building where we ask them to do things outside their development in order to mitigate potential impact of that. So the cost of that builder building on that empty lot should include at least the cost of determining whether he's going to create a problem. I mean, I firmly believe that. If it's nothing more than making him actually do some elevation mapping outside of that lot. Worst case that happens is that you go to the adjacent homeowner and say, when this house is built, you're going to have a problem.
Yeah,
and here's what you have to do to fix that problem. Now, and we're not going to do it for you, and we can't make him do it but you are going to have a problem, and here's why you're going to have a problem. So I personally, it's kind of one of these things is that, the yin and the yang here. Somebody's got to pay for it. I agree with you 100%. It can't be the city. We can't have the city engineer sending staff out there every time a house is built and trying to figure out whether there's a water problem on some other lot and try to explain that. But maybe the simplest thing to do is to basically change our land development code and require, the same thing we would require of a development. If you're going to build a house on an infill lot, you have to provide the information that determines whether that is going to cause drainage issues adjacent to you. And if, you know, I don't know, it could be as simple as an expanded elevation mapping. You know, maybe it may be that simple, and try to work through that process. But I don't think the city can walk away from this.
No.
And I don't think that we can fix it completely, but I think we need to do something. I don't see anything in here, and I know what you read, Mr. Mayor, but I don't see anything in here. Everything in here is all designed at protecting the city's drainage system. When you build, you will not mess up our canals, and you will not mess up our pipes, and you will not mess up our drainage ditches. And oh, by the way, when you put a pipe under your driveway on your new construction, you will make sure that the water flows through that pipe and it doesn't create a dam and so forth, okay? So it's, it's perfect the way it is. We want to protect our drainage system, but now what we have, because of the new rules, and I'm not sure how new they are, they've been putting septic tanks at these elevations now for several years. We're creating issues for homeowners that you know, they did their stuff right.
Yeah.
And at least all we can do is try to assist some way with that.
I need to respond to that because, in my opinion, that's incorrect. Because if we go to section 6, A4, it also says stormwater runoff should not encroach on adjacent properties except in proper drainage easements. Well, with that being said, if you had a house that was built 25 years ago and they've been draining into the lot next to them for the last 25 years, technically they're in violation of 4. Because their stormwater is not draining into the proper drainage easement, it's draining into the lot next door, which is somebody else's property. That's on page 96 of 188.
That's what I was trying to find.
96 of 188. So while they talk about you are not allowed to build something to inhibit drainage, we also have to understand the property owner of that empty lot has property rights as well, and technically, if the water has been draining into that property, which is what number 4 says is against the rules, against the ordinance, then technically, if we're going to force new builders to deal with the runoff from the neighbor's property when they build a house, then we're going to have to enforce section 6A4 of all the properties that are doing that now, so that the builders aren't being forced to do something that we should have already done.
Oh, okay, I'm not saying that
That's
we
not
should
what
force
he's
the
saying.
builder to deal with the
Right.
runoff from the adjacent property. I'm just saying that what we need is, we need something done at the time of construction that tells us there's going to be a problem. We don't want to wait. I'll point back to Andy down there, because I looked at that thing today on Sebastian Daily about the picture of the poor woman that had a lake in her backyard. We don't want to wait until there's a lake in the backyard to
Right.
decide that there's a problem, and then we can't fix it, then we're stuck, we have all the issues we have to deal with. And I don't know, maybe.
We are going to deal with many more of those, because her
so-
yard isn't a single, it
Yeah.
is not a single
Right.
entity. There are many of those houses around, and so, obviously, it is something that we have to deal with, but
Yeah.
while dealing with it, we have to be sure that we're not violating the other property owners' rights
So-
either. So it's such a
Well,
difficult
at-
situation.
At the
Is
last
there-
meeting, when I asked you to bring this back, the reason that I asked you to bring it back was that I think personally that we need to do something with our land development code, and I think that the council needs to provide you direction on, you have to come up, you guys, poor ladies in the front row over there, and you have to come up with that. The council can't come up with that, but I think the council needs to provide you with direction saying that we would like something done to address this issue.
I have a suggestion. Can we not have them put for any new builds that they somehow survey the properties next to them so they can figure out what's going on, so they can let the current homeowners or the people who've already been there understand whether they're draining properly or not.
Yeah.
And there can be a solution from the start instead of waiting until disaster strikes.
Yeah,
I mean,
so
that-
that's kind of what I had been talking about. I'm
Yeah.
sorry, Councilman.
I'm saying that could be a very good solution to the thing, but we have to, I mean, they've got to work through the whole
Right, of
process
course.
of, you know, the Wayne and the building department has got to, whatever they come up with has got to enforce it some way or
Yes.
another. The city engineer's got to be able to enforce it when they do evaluations and so forth. And, you know, I said earlier the same basic thing. I
Yeah.
think that, you know, to me, it's not irresponsible for us to ask a person who is making money in a business venture to spend money to make sure that their venture doesn't impact somebody else's property rights. We do that all the time in developments when we ask, I mean, that in my
Stretch that
motion,
into
I don't
faith.
want that in the
No,
motion. I'm just
not
saying,
financial.
I don't want that in the motion. I'm just saying the city, I do think the city has some responsibility, okay? But I'm not gonna tell you that in a motion. But I do think the city has some responsibility.
And I agree, the city has responsibility to help find a solution. It doesn't mean we are going to be the solution, but we do have responsibility to help identify a way of dealing with the problem.
I don't disagree with that
I
at all.
totally
Don't
agree with
at
that.
all.
And we do that today. The problem is the homeowner says, we get instances where the homeowner says, well, I shouldn't have to pay for that, but that's another subject for another day. But as Councilmember Dixon had just mentioned, one of my suggestions was to do, right now they don't do a topographical survey on the property, they do their design drainage plan. It would be an additional expense to do a topographical survey 5 foot outside the property line, but that would show the issue of the problem. That's just one of the.
And however you choose to do that, all I'm asking is that there be language in the land development code that stipulates what that is and whose responsibility it is to do it.
Understood.
That's all I'm asking for, because now, quite frankly, from the perspective of a council member, I can say, wait a minute, the land development code says thou shalt. Who is not doing this? And Joe Blow out there, who finds a lake in their backyard, can go to the land development code and hire an attorney who can say, well, based on the land development code, you caused this problem. Did you do what it said?
Well,
And that's up to Joe Blow. That's a civil issue. That's not our problem.
yeah, I don't want to get into that part of it because we make assumptions of liability without all the facts. But if consensus of council, you know, we've been trying to address this, and our staff has done a tremendous job meeting with these landowners and homeowners and helping them through the process to get through it. As I said originally, some of them just say no. But if it's a consensus of council, I think we could come up with a few ideas as long as it's understood that we're not going to go in there and fix the problem. We may alert them of a problem ahead of time, and we'll work with them to get through it. I think that is the consensus of council.
And I know we've played mediator in between trying to get, you know, the homeowner builder of the new property to work with us. Sometimes they're willing, sometimes they're not. So that would at least help maybe put more specifics. I think more specifics is probably the important.
We have to make the rules.
Sorry?
We have to make the rules.
Yeah.
That's
I
all
don't
I'm
disagree.
asking for.
Listen.
Is within the land development code, a set of rules that says if people do A, B, C, hopefully, it may not fix the problem, but at least it'll give us some indication that there is. I mean, I would not have an issue at all if the city were to send a letter to 3 property owners and say, based on this thing that's happening, you could have a problem.
Right.
I wouldn't have a problem with that. Now, we're not saying in that letter, we're gonna fix your problem, and we're just saying, and everything that's being done is correct, it's to the code, but you could have a problem based on the way your law, based on this information. At least we're not waiting until they have a lake to deal with it. You know, we're telling them they could have a problem at some point in time.
Right, so you have a consensus from us, right? So what type of time frame would you need in order to bring that back before us?
Well, it's going to be a couple months, I'm sure, because we've got to get it, we've got to search all aspects of it. It's going to be a good couple months before.
Well, no, that's fine, as long as that we're working on it, we're trying to address these issues, as long as we're moving forward and trying to address some of these issues and find solutions for all parties involved, that's great for me. Look, like we have someone from the public who would like to talk. Come on up. Well, somebody come up.
Sarah Carlson, homeowner. Just would like to point out a couple things. The city has been working with me on the photo that's being passed around the last couple days. The city has been working with me, and they have been very communicative, have helped me with mediation and, you know, working with the builder to flow water through the property behind me. Those things have been happening and very helpful. Yes, I do have a lake in my backyard. I have lost a building on my property, and so I do have some. I have never asked for said I didn't want to pay for anything. That's never come out of my mouth, so I just wanted to point that out. I do understand that I have responsibilities as a homeowner. I've just asked for assistance, and I wanted to also point out that when the home next to me did start going up, I did speak to the builder because I did foresee this being an issue when I saw the elevation of the property going up. I did speak to the project manager on site about it specifically, and he assured me that it was something that they consider and that it would not be a problem. Of course, that obviously is not what turned out to happen. So I just want a resolution, and it's turning into more of a problem the bigger the storms get than I expected it to be. I understand every property has its own unique nuances, and the inspectors that have come out to my property, they've identified what is the particular problem with mine. My house happens to be almost 50 years old. I have one of the older homes in town. So my property is fairly level and slopes towards the back. So my backyard is a lake. And, there's not anything I can do about that. There's really not anything I can do to raise my house up any higher. So I need the city's help. And so thank you. I appreciate it. And please continue working on this problem. Thank you.
Yes, ma'am. Thank you so much. Next person.
Marjorie Hale, resident and representing my mom, Ardith Hale, is a landowner. She lives behind the Winn-Dixie between there and Barber Street. We have seen, as the houses have gone up, that there has been additional flooding in the backyard, additional flooding on the streets. Anytime there's any significant rainfall, we have flooding. We've planted trees along the back to help mitigate, because we know that trees suck up water and your drainage will work better as the trees increase the land level in the back and drink up the soils. I don't know that land level is correct. That said, when they started building the house adjacent to us, as she mentioned, the property level is significantly higher. The silt fence that we insisted that they install has since been knocked over. We've sent emails to councilmen and to other persons regarding the blocked drainage, which sometimes gets fixed in a timely manner, sometimes doesn't. This silt fence is still leaning over months after when it fell over during the hurricane. That house being built is close enough to the property line and high enough that there's no way that they could maintain the off-flow to their property without it coming onto our property. It's not possible with where the house is located and the slope allowed to not be having a drop-off at the edge of our property. And we'd like to see something done. The back houses, the first one that went built, they assured us that all of their drainage would flow forward. It doesn't. The second house that got built, catty corner behind us, they've done some interesting swaling at the back. Not sure that it works, but it looks like it might help more than what they did on the original one. But I don't know what they're going to do for this side one, and we would like the city's help with that as well. I don't know if it's just a proximity issue or if they need to put in a French drain or what, but please look into how close that property is allowed to be built to a house that's already built, and whether or not that slope that's required by health and safety for their septic and drain field will meet the current land line of the adjacent properties.
All right, thank you, ma'am. Anybody else?
Good evening, my name is Amanda Longany Halpin. I am a resident on Nebraska Circle, Bryant Park area. We moved in here 4 years ago, a couple of storms, nothing major. We had a lot behind us that was empty, tried to buy it for ourselves, but it got sold to a company, and they built a house. Then we had some storms come through this year. In the middle of the storm, myself, my wife, my daughter were digging a trench in the front yard so that the 6 to 8 inches of water built up in my backyard with my pool, in my pool deck and my yard would drain to the front swell area so that it wouldn't come in our house. It's never happened before. So obviously there's an issue. With a little bit of research, it would be my responsibility to come to the city, zoning, planning, and asking what the plans look like and seeing if there is any draining component or drainage component that's built into those plans, which is required by SwiftMud. It's my understanding it's in the ERP permit portal. I don't know if that's what you guys use for your building permits as well, but there should be something in there from SwiftMud. There's a 2017 statutes for building codes that was also passed. I'm not legal, but I can understand a little bit of the basics to say it is the builder's responsibility. And there have been cases here in Indian River County where builders have had to come back and install a drainage system of some kind to houses that were there prior to new builds. My house was built 40 years ago, 45, and the land behind us was very level. So nobody was violating any drainage laws or statutes or rules in the beginning. But then what happened is this house was built a little high, this house was built a little high, these two on this side, but the one directly behind us, then once that was built up, now all of it is draining into my backyard. A little bit of help and wording into the laws or statutes requirements here in Sebastian so that they coincide and hold the builders accountable, because we know they're making thousands of dollars. And we as citizens are paying thousands of dollars in taxpayer money because we like our area. And we even tried to see if we could get some assistance because for whatever reason, my house was the only house in the entire community that did not get one of those drainage things under the driveway. Culverts, thank you. So now I'm, flooding in the back and in the front. Thank you very much.
Yes, ma'am. Thank you so much. All right.
Yeah, one more.
Do we?
My name's Kerry Allen. I'm on Nebraska as well.
Wait till you get to the podium, please.
Kerry Allen, Nebraska as well. I'm all about solutions.
What was your name? I'm sorry, we didn't hear it. Your name?
Kerry, K-A-R-E-Y, Halbin.
And you live in Sebastian?
I do.
Yes, ma'am. Go ahead.
One of the things that I noticed was said pretty quickly was about, the people that are there and building now, but the homeowners and the people that have been there for years, they've been paying them taxes, them big taxes for them houses and that property value. One of the things I noticed in our area is we actually have like drainage systems that are throughout our neighborhood that have to be maintained by the city. So if they're maintained by the city, that means that they know there's drainage issues within that city, that it's maintained. In my neighborhood particularly, the culverts that were built for everybody, except for a couple of people, why we don't know, we can't get any answers about that. But it was clear enough that there was a problem that needed to be addressed. And that was the city that took care of that, not the citizens going, no, they built that house, so now we got a problem. They knew there was a problem there. That's why they installed that, and it was probably voted on years ago before I was there. I've only been there for 4 years. So we already know that that's established. That could be reevaluated in some of these neighborhoods to say, okay, the drainage system for what you guys cover is dealt with. Is that something that taxes are helping out with? Is that stuff that's going towards that? Because I know different areas in Sebastian with like the city versus this part has different taxes. And, we also pay some to Indian River. So if they gotta piggyback in here and help out with some of this, because that's where it's gonna drain out to them, then maybe we need to think about getting them involved to getting a system out there as well. I'm sure we can think of some really great ideas. We got some great people in office that we could come up with some solutions to help out our citizens who are electing the people where they are. That's it for me.
Thank you.
All right, thank you so much.
Brett?
We have one
One
more?
more.
Hi, my name is Ardith Hale. I'm a longtime Sebastian resident. I've lived in the area for over 50 years now, and raised my children here very happily. Have a house on New Hall, which is 1 block long. It was built in '84, and I'm sure there was some fill under it. It was a well-built house. I've been told it's a very well-built house. My daughter addressed the construction in the area. My house is not very high. I mean, if you look at the street is down, yes, in front. The back slopes slightly down, levels off, and it used to be all woods around me except one side where there used to be a house which has since been torn down. Okay, now all except that one lot either has an existing house or a house being built. They're all 4 feet on the ground. The level ground that used to have trees and go down to the street and slope into the swale. That's all gone. Now they all go up. I called the engineering department here, and I was told that the drainage would be no problem. There was no way it would ever make a problem. Unfortunately, I didn't write the engineer's name down. I said, fine, we'll see, because I've always been taught that water flows downhill. Okay? Now, I noticed you mentioned the city's concerns with its drainage. And I've been very pleased with the city of Sebastian. When I first moved to the house, when we had a major rain event, the street would flood consistently, to the point where you could not drive out of your driveway, back out of your driveway, without drowning your car. And there was a couple times I had to call into work and say, I can't get out of my driveway. You're gonna have to wait at least half a day and maybe 2 days, depending on how bad it was. Now the city came through, they made drainage improvements, they dug a lake over on Tulip, they've done other things, they laid the swale liners, in some cases I saw they put new culverts in. They came and took our old culvert that crosses the road out and put in a new one and deepened the ditch on the other side, which was great. And then they addressed, I don't know who started it, but the flood was addressed. And I went from a flood zone A to a flood zone X. And I was pleased, because less flood means less flood insurance, which I carry. But this year, for the first time since the drain liners went in and all the work was done, my street was underwater. After, I know there are major rain events, but after the hurricanes, it went underwater to the point where all you could see of the fire hydrant was the top 3 inches. I took my grandson down, gave him a yardstick, asked him to measure the water in the road. It was 1 foot deep in the road. If you don't have a 4x4 or a high wheeler, you're not getting out in that. Okay? The builder next door was not diligent in keeping the culvert clear. He let it fill with sand as he brought in fill. And we called the city on that, and they sent someone out. I don't know if he cleared it or not, but the water was to the point where it was over the road. So this becomes your problem too. As you build each house higher and higher in an effort to prevent or to allow drainage and septic systems to drain, you're gonna have more and more water in the streets, because the streets have not been raised, and the old houses aren't being raised. We don't wanna be another New Orleans where we have dikes everywhere and we're the globe ground. You know, I'd just like to see some due diligence by the city. Maybe establish a zone between each house where there's a swale that is made to slope to the street. You know, maybe dig some more drainage lakes. I don't know the solution. I just know I don't want my backyard to become a lake. I don't want my house to go underwater. Okay, thank you.
All right, thank you so much. Council, are we done with that? Are we ready to move on to the next item?
I think city manager and staff has a
Yeah, very good.
movement forward.
Yeah, absolutely. So next, we'll move on to 12A, resolution number R-23-01. Mr. Attorney.
Thank you, Mr. Mayor. Resolution 23-01 is a resolution of the City of Sebastian, Indian River County, Florida, duly ratifying a 3-year agreement for all full-time permanent police officers and police sergeants between the International Union of Police Association, AFL-CIO, open print, IUPA, close print, in the City of Sebastian for the period of October 1st, 2022 through September 30th, 2025, authorizing the city's ratification and cause said 3-year agreement to be put into effect, providing for repeal of resolutions or parts of resolutions in conflict herewith, providing for scrivener's error, providing for severability, and providing for an effective date.
Thank you very much, sir. Mr. Carlisle.
Yeah, Mr. Mayor, members of council, this was a very robust negotiations. I think we've got an agreement that's beneficial for the employees and the city and the residents, and I think this is something that council should consider approving resolution 23-01.
All right, very good. Before we go for there, is there anyone from the public who would like to speak on this? Is there anyone on Zoom with their hands raised?
Nobody's raised their hand.
Mr. Dodd.
Mr. Mayor, I'd like to make a motion to approve resolution R-23-01.
Second that.
So we have a motion and a second. Any discussion? Roll call vote.
Mayor Jones?
Yes.
Vice Mayor Nunn?
Yes.
Councilmember Dixon?
Yes.
Councilmember Dodd?
Yes.
And Councilmember McPartlin?
Yes.
Thank you.
Now on to 12B, approve the purchase of 80 new golf carts with full GPS club. Mr. Carlisle.
Yeah, Mr. Mayor, members of council, this is a long overdue item. We had extended the use of those carts for 2 years because of the COVID. We had used them as single-use carts, our existing carts, and put extensive wear, but in doing so, we had to replace all the batteries in those carts, and so that's why we kept them for a longer period of time. And of course, we're having some mechanical issues and issues with them now, but it was always planned to replace them. We went out to bid and we received bids, and the most advantageous to the city is for Club Car LLC in the amount of $528,640. And that's a direct purchase. And I was asked questions about financing, and it's just an additional 4% on top of this to break it out in 4 annual payments and receive the golf carts. We also asked that we put GPS in there, and this is something that I think is beneficial to us, and I know the Director of Golf is here and he can answer more questions, but I think it's important because of a few things. One, we've seen a lot more extensive play out there, which is good and bad. And we can control carts when we have cart path only. We don't get damage on the golf carts. We have slow play. We can send them messages and say pick up pace so that you're not making other golfers aggravated. And we can manage the use of the carts on the course. And also, it has some other capabilities to help speed up play. GPS. We have a capability they can order some grab-and-go food from the diner as they're on the course. And all that is done to help create a more positive experience on the golf course. It makes us I think we're going to be one of the few in the county that have it other than the private golf courses. I think it's something that sets us apart. I think it lends to us a distinction. and a little bit higher quality performance and a higher quality experience. So with that, council, I would ask you to approve the purchase of the 80 new golf carts with club car, and also authorize us to install the full GPS, and that is $28,800 a year annually for the GPS service.
Right, yeah, it also has, other benefits on the golf course. We have people that drive the golf carts up on the greens, they drive them off the cart paths where they're not supposed to, when the course is super wet, yet they keep it open to allow play, but cart path only. That creates more maintenance work, which is more money there, more repair work around the greens for carts driving up and around those areas. So, not to mention the actual shop where people can order 3 holes before, so by the time they make the turn, they can actually have their food ready and they don't hold up play. So it'll speed up play, and it'll also help speed up play with the slower players that backs up the whole golf course. If you back up play for 5 minutes, then the 3 groups down, they're going to be 30 minutes further behind. So it really backs up things, and these GPS carts, I think, will help make that a lot better and preserve our golf course a lot better too. So this is my 2 cents.
Yep.
Mr. Nunn.
Obviously, the golf course is a very highly used recreational facility of the city, and it does good at making money. It pays for itself well. Our golf carts are in really bad shape. I think more than half of our existing fleet is down with bad maintenance issues or end-of-life maintenance issues. So this is definitely going to give us a boost of a financial boost down the road here. So I think it's a great thing. I'm glad to see we're finally getting some golf carts.
Yeah, no, that, hang on, Ms. Dixon.
I was just gonna say, as someone who is on cart duty often while my son and his buddies play, they're almost impossible to steer at this point, so it's definitely long overdue.
Yeah. Mr. Dodd.
My question has got nothing to do with the golf carts. I'm very happy about that. The GPS is a great attachment, a great addition to the golf carts. It'll stop some marshals from getting slugged in the nose for telling people to speed up, maybe, or something. So, some of those things. But I can't remember the last time they told the mayor he has to play faster. But my question is the financial side of it. Okay, if I go out to the capital improvement budget within our 22-23 budget, we've only got, over the 5-year window, we've only got $400,000 in there. So my question is, and I'm not arguing about the dollars at all that are in here. I'm just wondering exactly how we balance the financials in this between the capital improvement budget, which has actually nothing for the 22-23 year. It has $135,000 for the 23-24 year. So how are we going to balance that?
So we're not getting, it's going to take a year to get the cart, so it's going to be split between the 2 years.
Okay. And are we going to see, like in the quarterly report, an adjustment to the capital improvement budget for the additional funds, or is this going to be financed through a loan to the golf course that's going to be paid back over time from the golf course, or how are we going to,
this is not
outright
coming,
purchase?
This is not a loan, this is coming out of the golf cart reserves. Okay. So that tells you where we are with the golf cart reserves. We have funds in there to.
You have enough funds in there to pay for it?
Because it's split over 2 budget cycles.
Okay. Yep. So the capital improvement budget, this money that's in here in capital improvement is actually from the golf cart reserves itself.
That's correct.
And it's got 400,000 in here, and we're going to up that to about 528,000. So, and the other $128,000 will come out of additional golf cart reserves.
Yeah.
Okay. All right. I'm fine with that. Now, I just had a question about that.
Yes, sir. Any other questions, Mr. McPartland? Nothing?
I guess it's the cost of doing business. But, you know, the one thing I wonder about is do we have a real good warranty on these carts? Because I remember several years ago when we bought the carts, then we had to replace all the batteries. And that was a significant cost that we were associated with.
Mr. Mayor, I can answer.
No, yeah, the last time we did that is because we were doing the COVID years and we had the single-use carts. So the hours, the batteries don't run on how many rounds you use. It's about what they call it, energy units or something, yeah. Right? So each one of them about 25,000. You can get about 25,000 energy units out of each one. The problem we had with the carts during COVID is they were running them so much they didn't get a chance to replenish and do the things, and then they didn't catch it in time as far as the warranty on some of them because the company failed. Mr. Carlisle, you can explain that a little bit more.
So it was COVID, and we stayed, you know, where others closed, we stayed open, and we did single-use cards so that we could give people an out, so they weren't locked indoors, and that created us going over those 25,000 energy units, so the batteries fell out of warranty. However, there were batteries that were still under warranty, that had they been replaced under warranty, we would not have had to purchase them, and it's not a lot, but it would have been some dollars we would have saved. The golf cart company that's in charge of the maintenance, we can't get batteries, we can't do this, you know, we can only do like 5 carts at a time. So I'm having our purchasing agent write the contract. We're not gonna use Club Car's contract if we don't have to. I'm trying to write a contract. We don't care what company Club Car used to service our carts. Our contract is with Club Car. Our contract is not with XYZ Golf Maintenance Company. We ended up going to Club Car Atlanta because of that situation you're talking about, council member, and you're exactly right. We were being piecemealed along on the batteries because they were only going with one battery. We ended up getting all the batteries at one time to replace all the batteries in all the carts. So when you tell me there's no batteries and I can go down to the local battery shop that supplies golf cart batteries and I can get them, it's a little bit of a challenge for me because you're stuck on this one battery and that doesn't allow us to service our carts and perform. So we're going to try to address that in a contract, and I appreciate you bringing that up because I think that's very important. Performance of the contract is paramount to us being able to utilize the carts. And we're going to try to address that in a contract.
Because I bring that up, it wasn't just this past COVID with the batteries. I guess either I'm old or I just have institutional knowledge, but I think this is about the 3rd time that I've been around buying golf carts, and every time there is something that goes wrong with these carts that we buy. And of course, then it comes back and it's, you know, $50,000 or $100,000. Oh, it's just going to be this one time. This just seems so, just watching the warranties, like you said, we got them from you, you fix it. We don't want to go to the next guy. And it's just, and because not everybody plays golf. And so there are a lot of citizens that, you know, they come up to me, well, we buying, you know, $500,000 on carts again. But then again, it is the cost of doing business. You need to have reliable carts. The GPS is a good idea adding on. I don't know, have we considered increasing the round of golf $1 a round to, you know, fulfill the cost that's being added? Because basically, this $30 a month a cart is $1 a day. And the carts are used basically about twice a day. So have we thought about increasing 50 cents a round, $1 a round to offset that cost?
And we have discussed that, the cost of for the cost of the GPS, and also because of just the cost of maintenance. We just had to raise the golf course maintenance fee because of inflation, and we didn't adjust the rate. So we're going to have to look at that for both of those issues. One, the amenities that we have, and two, the cost that we raised on the maintenance fees last year because of inflation, and that contract's coming due. And we don't know what that new contract's gonna charge us, so that'll have to be adjusted then. Inflation hits everybody. It's not just at the supermarket, it's in recreation as well. So yes, sir, we are looking at that.
All right.
When was the last time golf rates were changed?
It was 2 years ago. Well, I think we raised it $2, and then we raised it $25 on the annual membership fee. And that was about 2.5 years ago? About 2.5 years ago.
Thank you.
All right, very good. Any more discussion on this? Let's call a vote. Madam Clerk?
Vice Mayor Nunn?
No?
Do we need to make a motion first?
No, did we make a motion?
I don't think we have a motion.
I would
Okay.
like to make
No,
a
I was
motion
reading
to
for it.
approve the purchase of the golf carts
All right, second?
And the GPS?
and the GPS.
And the GPS, second on that. Any other discussion? All right, call the vote, Madam Clerk.
Okay, Vice Mayor Nunn?
Public.
Oh, yeah, dang.
1 second, Ms.
1 second, Madam Clerk.
Okay.
Is there anyone from the public who would like to speak on this issue? Anyone on Zoom?
No one has raised their hand.
Hearing none, call the vote.
Okay, Vice Mayor Nunn?
Yes.
Councilmember Dixon?
Yes.
Councilmember Dodd?
Yes.
Councilmember McPartlin?
Yes.
And Mayor Jones?
Yes.
Motion carries.
And we'll move on to item 12C, authorize the city manager to execute the Walmart opioid settlement agreement. Mr. Carlisle.
Yeah, Mayor, members of council, this is a settlement agreement that the state attorney, the Florida Attorney General, brought against several companies, Walmart happened to be one of them. Walmart settled the case, and though we didn't have to be part of it, we are named as a beneficiary, if you would use that term, to some of these funds. And unlike the one that came up a few years ago, and I don't believe you all were on council at the time, the national one, it was 960 pages of stuff you had to do to try to utilize that money. It was too burdensome, too long-term for so little money. This is $10,800, and it is 22 pages of uses, and I think the whole agreement's 196. But the uses are so easily accomplished by us that, you know, I talked to the city attorney, and he read the documents, and he agrees that this one, and I talked to the chief, and he feels confident that the three uses that we outlined in there, education, training, and Narcan, are three vital uses that we can utilize in our community. They get grants now for Narcan, but how long is that going to last? This is going to help us with drug prevention, drug awareness, and how to handle and deal with drugs and when you run into them. And we know the fentanyl is a big issue for us. And constant, you know, when you do training, you respond by the training that you do. So that's paramount. And keeping our officers safe and providing them the tools to save the life of someone who may have overdosed on these opioids. So I'd ask that you approve and allow me to execute those documents for this settlement agreement and send it back to the state for us to receive those funds.
Council, anyone have questions or statements? Hearing none? All right, well.
Move approval.
We have a motion to approve.
Second?
Second by Vice Mayor Nunn. Any discussion? Seeing none?
Well, I'd just like to make a comment,
Yeah,
Mr.
go ahead,
Jones.
Bob.
You know, $10,000 seems like pittance to me, you know, and I just think about this, you know, fentanyl is a huge problem. It's been a huge problem in the state, in the country, in the world. And I just go back to thinking my day job working with families and fentanyl, and I can recall right now, you know, 3 parents that passed away, left their kids orphans. So 10,000, I think, should really go towards, you know, I don't know, awareness. I remember, you know, 4 or 5 years ago, we had an opioid summit here in City Hall, and several people come down because it's not going away. It's just getting worse and worse and worse. And again, I mean, 10,000 really does, it does nothing, unfortunately. I mean, these companies made billions and billions, and the effects are not just in the people that are overdosing. I also think about the babies that are born fentanyl positive and the repercussions that those children are going to go through and what that costs the state and is just unbelievable. So again, I'm for it, but you know, 10,000 is
Yeah, but it's still enough to help out our police officers. Those guys and girls are on the front line out there. When someone's having an overdose incident or whatever, they are there, and I really like that. So.
To piggyback on what Bob said, Mr. Carlisle, you and I spoke earlier this week, and I would really love to see our police department get back into offering rad kids to the kids in our community, whether through the COPE unit or however they do that. I know they used to do that a few years ago. My children benefited from that program, and a lot of the kids could really benefit from that program. It's kind of, you know, I grew up with the DARE program as a child of the 80s. The Rad Kids not only discusses, you know, saying no to drugs and things like that, but it also offers self-defense and just gives kids more confidence to make the right choices. And so I would really like to see our city get back towards the more preventative measures for our youth. After all, they're our future.
That's right.
So is that it? So where do we go from here? We need to make a vote on this?
Yes. Public.
Yeah?
Public.
Yep. All right. So no more discussion? Is there anyone from the public who would like to speak on this? All right. Seeing none, anyone on Zoom?
No one has raised their hand.
All right. Madam Clerk?
Councilmember Dixon?
Yes.
Councilmember Dodd?
Yes.
Councilmember McPartlin?
yes.
Mayor Jones?
Yes.
And Vice Mayor Nunn?
Yes.
Motion carries. Thank you.
All right, the next item on our list is the review and consider our meeting calendar for the year. Everybody had an opportunity to look at that? I'm okay with what's on there, so I don't have any objections to it.
No problem.
Yep, we're
Are
good.
We're good.
Are we altering, our November or December dates, or will we wait till later to make that decision?
So we're not gonna have early voting because we have to pay for it, so, Madam Clerk.
Oh, yeah.
So were we keeping the meeting on August 9th?
August.
When's the
Normally
legal-
Because I'm
move
just
that
looking
to the
through the
10th.
calendar, that's what you proposed, the 9th?
Oh, yeah, I see.
Yeah.
And usually a League of Cities, sometimes they have some,
We normally would move that before, because
Right.
Wednesday they have sessions at the League of Cities Conference.
right, sometimes Tuesdays even,
Yeah, sometimes
afternoon,
even Tuesdays,
you
so.
know?
Right.
Yeah, when we find out more about what the contents of the
We can
session's
change.
gonna be, we can change it then, I think.
Yeah, yeah.
They haven't
November
actually announced
22nd.
what the stuff's gonna be in the early stages, and sometimes that stuff they do that day, nobody really cares about, so.
But you'll be there, right? I'll be there.
I'll be
too.
there,
Yeah.
yeah.
I'll
Okay.
be there after I get my kids off for their first day of school. I'm not
All right,
missing
so
that.
we're in agreement that everything is good for now. If we need to adjust for the August meeting and meetings after that, then we can do that at another time, correct?
Okay.
All right. City Attorney matters. Mr. Nunn.
Yes, thank you, Mr. Mayor. The only thing I have is that we're gonna, obviously, the 31st, in case anyone wants to be there, we're gonna be negotiating with now the general employees, or continue negotiating with the general employees and the supervisors, and hopefully we'll have a ratification resolution for council soon thereafter. Nothing further.
All right, thank you very much, sir. City Manager, Mr. Carlisle.
Again, I would like to wish everybody a Happy New Year. This is our first meeting since the new year. As you all are aware, brief notice that Hurricane Ian and Hurricane Nicole, we were both declared as natural disasters. So there's small business loans and that available from the SBA. And we'll put this contact information on our website. The application filing deadlines, start deadline for Ian is January 12th, which is tomorrow, and ends on June 29th of 2023. And Hurricane Nicole, the application is February 13th, and it ends on September 13th, 2023. But we'll get that information out there. It's low-cost loans for businesses. There's home loans, there's agricultural loans, but they can go through the thing. If they had suffered damages or losses due to Ian or Nicole, since we were declared, those funds and those low-interest loans are available to our residents and to our businesses. So that's all I have.
Very good. City Clerk, Jeanette. Nothing. Okay, that's fine. Vice Mayor Nunn.
Yeah, I would, like to say, I know we're talking about Harbor Lights Motel down the road, but maybe over the next month or so down the road, we could start thinking about the old compound and what we'll do with that down the road. So everybody thinks about that and moving forward. I'd like to say thank you to whoever felt the need to vandalize my truck a few weeks back. It's not appreciated. I take good care of my truck, and it's not appreciated for somebody to decide to vandalize it. So it's fixed now, and I just would appreciate talking to me next time. Thank you.
All right, sir. Councilmember Dixon.
Nothing today, thank you.
All right, thank you so much. Councilman Dodd.
Yeah, I've got a couple.
No way.
Yeah, just a couple.
Surprise, surprise.
And just as a reminder, Mr. Vice Mayor, somebody keyed my truck 2 years ago. I don't want to suspect who it was. That was during the Troubles. But, they keyed the front and the back and the side really well. Okay, I think at your seats, the city clerk put a copy of Resolution 23XX. It's a sample. I wanted to bring this forward for the city attorney and city manager to bring back at our next meeting, but this is a resolution basically supporting the Florida League of Cities positions for this legislative session that's coming up. The reason I'd like to ask the clerk to give you a copy of it is if you have any issues with any of these things, should give you an opportunity to talk about them, and maybe you can talk to the city manager about modifying a resolution if it needs to be. This is a sample, I think, that came out of Port St. Lucie, is where I got it, so it came from that regard. Also, I'm going to send the city attorney's presentation. Don't anybody panic. You don't have to listen to it again. But, I want to send the city attorney's presentation to the Florida League of Cities, to view. They're very interested in citizen education. And I know a lot of people listened to what was being said with a grain of salt, but quite frankly, the more the citizens know about the way that things work, and the more the citizens know about the city and know about what we do, the better off we are. I have to, okay, when you're talking about Harbor Lights, you're gonna bring that up, Mr. Mayor, but I wouldn't mind seeing an inventory of city-owned property. I know you've got it probably, that we could, if we're gonna talk about what we wanna do with Harbor Lights, maybe we should see the inventory at the time and then see if there's anything that you guys, any pieces of property that you feel like that we might wanna have a general discussion on property and whether we should do something with it. I don't know, it might be an interesting conversation to have while we're talking about Harbor Lights and some of the other places. Yeah. But now, I owe the mayor an apology. At the awards dinner, the mayor gave me something and asked me to present it to him at this council meeting tonight. And, and I actually left the house and forgot it. And I'll tell you what it was a box of crayons. And I couldn't understand why the mayor was asking me that. I spent the whole evening, I didn't even have any fun at that party after that because I was trying to figure out what the mayor was trying to do. So I went back and did my research, and I found out that a lot of Marines eat crayons. You know, and I don't want to be derogatory towards the Marine Corps, so I'm thinking back. I have a lot of relatives that were Marines. My brother-in-law was a retired Marine colonel. My niece is active duty Marine right now. And I know you don't know this, Mr. Mayor, but I spent 13 weeks of my life, a lifetime ago, in a training session that was a joint military training session with Marine Corps field operatives that were in that 13-week training. I didn't see any of them eating crayons during the whole time we were there. I actually thought they were kind of sharp. You know, they seemed to be pretty intelligent people.
Oh, they were probably office pogues. When you eat crayons, you're able to camouflage yourself in the woods.
Well, I understand, but they were field guys. They actually went out in the boonies, and I saw them put camouflage on, and I saw a few of them eat some of that, I think. But that was the stuff out of the cans you rub, you know, when you do that. And they did eat aluminum cans as they were trying to get the beer out and didn't know how to do the pop top. But I apologize, I didn't bring that. You know what, I'm going to have to stop you right there, sir. I did do something with that box of crayons, because these guys that I went through that training class with, I remember them, and I was thinking, if they were going to eat a crayon, it would be a red one. Oh. So I took the red crayon out of the box, and I was going to give you the rest to let you decide which color you wanted to chew on.
I'll just chew the rest of them.
Okay, that'll be good. So I'll bring those to the next meeting, but I just wanted to extend that apology to you. So.
That's awesome. Thank you.
Thank you.
Yes, sir. Thank you so much. Mr. McPartland.
My God, I'm all confused now. But I went to 6-month Navy school. We had all the services there, and the Marines, now some of the Marines in there, I think they probably ate lead-based paint as children. But I never heard of eating crayons before. So, but I have nothing further, just Happy New Year. I think we got a lot coming forward before us for the coming year, and I think we're ready. So, thank you, Mr. Mayor.
Yeah, absolutely. So I have under my matters to talk about the Harbor Lights. I know, Council, we tabled this or something because, and not knowing what we're going to do, I'd like for us to move forward with our property. I know we're having that passive park that's going to be completed on the property that's across the street there, but where the Harbor Lights is, the building has been raised now, and any issues that were there have been mitigated. I'm looking to maybe have consensus from the council if we want to have the city manager look at this, put it out for bid, and try to get this property back on the tax roll and have some businesses built down there along the riverfront. So, anyone have any thoughts on that? I'm here.
Are we required, since there's no longer a building, to get that property reappraised, or no?
Mr. Mayor, may I?
Yes, sir.
So we had it reappraised, and he gave the building no value.
Okay.
So the appraised value is what it is. If you want to put this on another agenda, that's fine, or we can, well, we're in a unique position with property when we sell property as a municipality. We can dictate what goes back on it. We can put parameters, we can put timelines, and we don't have to accept the highest bid. We can accept the bid that's most advantageous for the city, that meets the goals and objectives of the city when we sell it. And last time we had it, we wanted it mixed use, commercial, residential, but we didn't want it to be strictly residential. I don't know if it's beneficial if we bring it back or we use that same parameter. That's where I need consensus.
No, I would say use the same parameters because, that's where I would be leaning, and not residential, but business and residential. So it's
Correct.
mixed use, right?
I don't think we want anything on the riverfront that's not. Sorry, I don't think we want anything on the riverfront that's not mixed use,
Yeah.
commercial,
Right.
residential.
We'll work on that proposal.
Yeah.
So, yeah,
But
move
I
forward with
also
it.
would like, I mean, I think it might be time for us to look at that whole inventory and see if
Absolutely.
there's other property out there that, you know, if we've got something that's, we've owned for 40 years because it was given to the city by General Properties, you know, during that trade out, and it's sitting there, it might be worth thinking about selling it, so.
We can definitely take a look at that and provide you all with that
Yeah.
and a map.
Yeah, absolutely.
We got a new GIS person, so we can make maps. Ross is here.
All right,
Ross
so.
is in the house.
All right, so I think we're done. I think we'll go ahead and adjourn the meeting. It was a great meeting, and thank everybody for coming. I'm glad that we had our first meeting of the year. We had prayer to open our meeting, so that, and I look forward to doing that for the rest of the year. If anybody knows of a pastor, a rabbi, or whoever would like to come and speak to us, I'd like to have this at every council meeting. So if any council or anybody else has someone, get them to contact Jeanette, and we'll actually put them on to pray at our meetings. So after saying all that, we're done. It's closed. Meeting's adjourned.